Hey, it's James, Father's Rights and Resources, hashtag how I got custody. If you're firing your attorney, or you want your attorney to go away and you're done with your attorney, and you finally came to the revelation and realization that these attorneys are no good and you're better off representing yourself, there's a way to deal with it. If you let your attorney withdraw from the case, their withdrawal is usually not effective for 10 days. So if your attorney quits the case, your attorney says, I can't represent you anymore. You want me to do too much. You want me to go for 50-50. That's impossible. I'm a sellout. I'm a quitter. I'm a sissy little limp-wristed cowardly bitch who won't fight for anything in court because I just roll with the system. I became a lawyer just to be a sellout. Your attorney wants to quit. A lot of times they'll put a withdrawal notice in, or you have an argument and you tell them they're fired. They'll file a notice of withdrawal. Don't do that. If your attorney is fired, first of all, you want to put it in writing. You want to state in writing, effective immediately, you are terminated. And I like to, anytime I have a couple videos on letter writing on my YouTube channel. Guys need to have, or parents, mothers, dads, need to have a paper trail with everything that they do. So, you want a paper trail when you get rid of your attorney, because you don't want the attorney withdrawing and you're still stuck with them for 10 days. So when I write an important letter, I will write it, I'll create some letterhead, my name, address, phone number and stuff, and then the date, and then I'll put attorney so-and-so, address, bar number, phone number, fax, and then I'll put regarding, RE, termination effective immediately, dear so-and-so, effective immediately, you're no longer my attorney of record, you're terminated starting today, I'll be representing myself in court, or that's the end of it. Signed, then put your name. And then you can copy and paste that into an email. You could print it out and sign it and scan it to a PDF or a JPEG or a TIFF file and attach it to that email. When I have an important letter, I email it, I fax it, and I'll deliver it to the lawyer's office. I don't like mailing if I can deliver it to them and have a copy of my own in hand. And most receptionists or lawyer's office will have a timestamp or a stamp at their desk that says received. So the attorney can't say, I didn't get your email, or I didn't get your fax, or I didn't get the delivery. We lost it or whatever. Well, you did it 3 different ways. There's no way you didn't get it. You could do certified mail if you want. I like to do priority mail. You could track it for any type of letter that's important. Anytime you send a demand or something really important, you should send it a couple different ways so there's no excuse that they didn't get it. Now, when right after you fire your attorney, or the day you fire him, if you haven't planned, like you're talking Friday and arguing with them, and you know what, you want that attorney gone on Monday, and you want to start filing motions and get on the offensive, then you can, have that, email that letter Sunday night or something, or deliver it to them on Monday, and you file a notice of pro se appearance, or notice of appearance, and within there, you tell them whatever. So you have, pretend this screen is a court document. Up in here, you have the name of the case. Like in my case, it was James Christensen versus Sedaris Wright. And then in this box over here, it said our case number, 015-007-956 SEA. I could say it because it's a sealed file. Nobody can get in there. Notice of appearance. The title of the document is up here in the caption. I talk to people all the time. I need to do a video on listening because people don't listen a lot of times. I'll say, what's the name or title of your document? And they'll just start reading the body of it. No, what's the name of the document? The name of a book is on the cover. The name of a report is at the top. The name of anything is usually the highest thing up. So if I'm asking for the name of a document or the title of the document, I'm looking for the title. And if you've been in court enough, you should know something. You should be picking up on stuff like this. There's some stuff that you should just be picking up on. When they say, the father's declaration or the father's trial brief or the father's motion or the father's request for admissions or whatever. When they make reference to a title of a document, you can know what document they're talking about because at the beginning of the document, this is called the caption. I don't expect all you guys to know that. They don't really throw that word around. The caption of a case is at the top. Some states have, the lawyer has their name and address. Some states, they have the name and address in the footer. But there's always a caption. And there's a case number in there and the title of the document. Some states, below the caption, they'll write the title here. But usually the title is in big, bold, all caps letters. So if somebody asks you, what's the name of the document in front of you? Or can you find this declaration? Like I'll tell people, hey, find me the petition to establish a parenting plan or, petition for dissolution. And then they'll start reading something and they'll say declaration of mother or, petition to modify. Or I said, no, I said petition for dissolution. This is where people have trouble listening. You gotta, when you're looking at something or paying attention to something or need to heed something or need to read something or need to know something, you should pay attention to every single word. If I say elephant, I don't mean eel. They both start with the letter E. But just because I start with the letter E doesn't mean you could talk about an eel when I'm talking about an elephant. Those are two totally different animals. A lot of people say, oh, you said, you said deposition. And then they're talking about a declaration. Those are two entirely different words, and you're not listening. So people need to develop that skill. But back to what you need to do, and you need to listen to what I'm saying right now and do it the right way. In the caption, you would say notice of appearance or notice of appearance pro se. Pro se means for self. It's Latin, like a lot of legal terms. They love to make themselves feel really smart. And they throw out these Latin terms because they sound fancy. These prima donna, arrogant, aristocrat, little pompous bitches in court. Oh, we got all these legal terms to make us sound smart. They're dumb as a rock in regular everyday life. So, in the caption, you say that. And then you just have a paragraph. I'll say, James Christensen makes this appearance in the case pro se. I am representing myself. My attorney of record was terminated on March 1st, 2024. It's May 14th right now. May 14th, 2024. Attached herewith is my letter terminating my attorney, effective immediately. Now, there's some states where they'll say, well, you need to go to court and motion to release your attorney, or you need to get permission to drop your attorney, or the attorney filed a notice of withdrawal. They're your attorney. No, they didn't. Or they may have, but they were fired. Think about how stupid that is. Let's say you're fired from a job. Will you show up the next day and say, I put in my 2-week notice and stay at the job for 2 weeks? No. The attorney is fired. They don't get to put in 10-day notice with the withdrawal. The other thing is, the court does not have a right to dictate every aspect of your life that you have a freedom and a right to do, such as hiring and firing a lawyer. Did you go to court to get permission to hire a lawyer and look for a lawyer? No. But some of these stupid ass courts will say, oh, you have to get our permission to let your lawyer go. I hired the lawyer. How come I can't fire him? Give me some legal authority behind that. I have videos where I talk about, I tell you guys, you need to demand from people. Where's the legal authority that allows you to tell me that? You can't come, if I come to court and you ask, did you do the dishes today? And I say, no, why? Well, I'm going to throw you in jail for that. You can't do that. You don't have a legal right to do that. The court only has a legal right to do what they're legally allowed to do. If they order child support, if you make $2,000 a month and they order child support as if you made $5,000 a month, that's just as stupid and as illegal as if they threw you in jail for not doing dishes. They are limited. There's some things that a lot of you guys out there, you just go through the motions and you hear one sentence and you regurgitate that and you don't absorb it. You don't understand it. You don't care enough to understand what's going on. If you understand the scope and the power and the limitations of a judge, you will be able to stand up to them. A judge cannot come down from the bench and say, this is my courtroom. I get to do whatever I want. I'm going to stab you right now. That's illegal. Whether it's in a courtroom or out of courtroom. Judges say, well, this is my courtroom. I'll do whatever I want. No, you won't. The law limits how much child support, how much alimony, whether you can grant a restraining order. I didn't commit harassment or domestic violence. You can't grant one. You can't stop me from speaking in court. I have a constitutional right to be notified of a proceeding and be heard and a chance to prepare. You can't do this. If you know the boundaries of the rules, you have some balls to stand up to a judge and tell them that they can't violate, you will. But most people don't do it, so judges get away with violating stuff, and so now the judges are just running roughshod and being dictators to everybody else. Put them in check. So don't let them tell you you can't fire your attorney and move forward immediately, because once you fire them, they're gone. Notice of appearance and notice of pro se appearance.